So I want to talk about a Supreme Court case. Taylor v. Riojas, R-I-O-J-A-S. R-I-O-J-A-S. Taylor v. Riojas. Taylor v. Riojas. This is a 2020 Supreme Court decision, so this just came down. Now, Trent Taylor had to stay in a jail cell full of shit for 6 days, and he lived to tell about it. He was incarcerated in a Texas prison. And the allegation, we're going to presume that what he is putting down is true. He's going to have to prove this later. But he alleged that in September 2013, correctional officers kept him in a pair of disturbingly unsanitary cells for 6 full days. The first cell was covered in massive amounts of feces. There was waste on the floor, walls, windows, and even packed inside the water faucet. Taylor didn't eat or drink anything for almost 4 days for fear that his food or water would be contaminated. Officers then moved him to a second cell, which was extremely cold, lacked a bed, lacked a toilet. There was a clogged drain in the floor, which provided the sole means of disposing of human waste. The drain was clogged. So Trent Taylor, he said that the officers refused to take him to the bathroom. Being concerned that if he urinated, the drain would overflow, he held his bladder for 24 hours before involuntarily urinating. The drain ultimately did overflow, covering the floor with feces. Confined without clothing, Taylor was forced to sleep naked in sewage. Living in sewage for 4 days? He's staying in this jail cell full of shit, and then they move him to another one because clearly this isn't good enough? My God, this is cruel and unusual. De minimis fringe benefits, too trivial or minor to merit consideration, especially in law. Now, Alito is going to write for the majority, and he's going to sit there and say all this legalese. As stated in our rules, a petition for a writ of certiorari is rarely granted when the asserted error consists of the misapplication of a properly stated rule of law. This court's Rule 10. His case would have been remanded for trial on the claims that remained after the Fifth Circuit's decision, one of which sought relief that appears to overlap with the relief sought on the cell conditions claim. And if he was dissatisfied with the final judgment, he may have been able to seek review by this court of the cell conditions qualified immunity issue at that time. Major League Baseball Players Association v. Garvey, 2001, per curiam decision. I agree that summary judgment should not have been awarded on the issue of qualified immunity. We must view the summary judgment record in the light most favorable to the petitioner. When the petitioner's verified complaint is read in this way, a reasonable fact finder could infer not just that the conditions in the cells in question were horrific, but that the respondents chose to place and keep him in those particular cells, made no effort to have the cells cleaned, and they did not explore the possibility of assignment to cells with better conditions. A reasonable corrections officer would have known that this course of conduct was unconstitutional, and the cases on which respondents rely do not show otherwise. So he's going to do, a lawsuit. He was able to live to tell about it, and he was able to write a lawsuit, and it goes to the district court in Texas, and they summarily say, fuck you. It doesn't matter what you say. And they say it's not good enough. Because a reasonable officer, he didn't know that was unconstitutional. What? Throwing a man inside a prison cell with a bunch of shit? That's against the Constitution? Since when is it the 8th Amendment, motherfucker? When it comes to well-settled law, is there anything more well-settled than the Bill of Rights? I don't know of any law. If the Constitution isn't well-settled, well, then we got a lot of problems in this country. Because we're not going to say that case law or the code, the statutes, we're not going to say natural law or common law is well settled if we don't know that the Constitution is well settled. Let's go ahead and read the 8th Amendment for all the police officers and prison guards who don't know what the 8th Amendment is. The 8th Amendment is as follows. Don't be cruel and unusual with your punishments, okay? I don't have it pulled up here, but it's going to come up here in just a second. 8. No, this is the cruel and unusual punishments are illegal. Let's get it out of this one. Maybe we'll get to it quicker with this one. Okay. Dun, dun. The 8th Amendment says, Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. That's cruel and unusual. We're just going to throw them in a jail cell full of piss and shit, and they're going to throw the food in the piss and shit, and have them eat out of the piss and shit, have them eat the food out of the piss and shit, and who cares if there's maggots or contamination, and then after 4 days we'll put him in another cell where the drain is clogged, and he still won't be able to piss and shit down the drain because there's no place for it to go, so he'll have to just piss and shit in his own, live in his own, basically it's a hog living in his own slop. A hog living in his own slop. Cruel and unusual punishments cannot be inflicted. That's the 8th Amendment. Oh, well, we didn't know about that, Your Honor. We didn't know about that. So that's Taylor v. Riojas. Riojas. I wish I could pronounce that Riojas a little bit better. But the Taylor decision, the 2020 Taylor decision, Taylor v. Riojas. Holding, because any reasonable correctional officer should have realized that Trent Taylor's conditions of confinement offended the 8th Amendment, the U.S. Court of Appeals for the 5th Circuit erred in granting the officers qualified immunity. Judgment granted, vacated, and remanded in a per curiam opinion on November 2nd, 2020. And of course, we all know what per curiam is. Per curiam is by decision of a judge or of a court in unanimous agreement, denoting a decision of a judge or of a court in unanimous agreement, a per curiam decision. So, decision by a judge or the court, so it seems like it's a unanimous decision by the entire court. But actually, Amy Coney Barrett didn't take any part of the consideration, so she abstained. I don't want to vote on this. No, I don't think that this is a rise to the level of me putting my signature on this decision. Really? Really? You don't think those are enough fucking allegations? Later on, he's going to say, well, he's going to have to prove his case. But you have to, the allegation, you got to believe the allegation in the light of his proceedings and then file against them, and then they have to respond. Now, they could say there's no evidence. They could say this or that or what the fuck ever. None of that happened. It's all bullshit. But if you're going to pretend that the court system works, then the complaint that is filed, unless you know that this person is a pathological liar, you got to, that could be a defense for the prison guards too. He's a pathological liar. So, judgment granted, vacated, remanded in a per curiam opinion, November 2nd, 2020. Justice Alito filed an opinion concurring in the judgment. Justice Thomas dissented, but he doesn't give a reason. He just said, no, that's not good enough. Holy shit. It would have been easier. There's a case where the guy just gets eaten up by the flies. Now, not a case, but a media report. So, let's see. Man eaten by flies in jail. Family of man says is eaten alive by bed bugs in a Fulton County jail. Man eaten alive by bed bugs in a county jail. Man eaten alive by insects and bed bugs in an Atlanta jail cell. This is USA Today, ABC News, Miami Herald. So let's see here. It says, let's see, LaShawn Thompson was found dead in a Fulton County jail cell last fall, having been eaten alive by bed bugs. This was April 13th, 2023. This happened last year. The guy seems like an okay guy. He's sitting there cheesing, he's smiling, he's got a kind face. LaShawn Thompson, 35, was arrested for a misdemeanor simple battery in Atlanta last summer. Officials said taken to the Fulton County Jail where he was placed in a psychiatric wing after officials determined he was mentally ill. Yeah, I'm sure. According to a Fulton County Medical Examiner's report obtained by USA Today, Thompson was found unresponsive in his jail cell September 19th and pronounced dead after failed life-saving attempts by responding local police and medical personnel. The officer stated that it is unknown the last time the decedent, which is such a fucking Orwellian term, the decedent, the dearly departed. How about that? The man who was alive, who had soul, who had breath, who had a spark of God in him. The decedent was seen as the case continues to be investigated. The October 26th report continues. There's no obvious signs of trauma on Thompson's body, the coroner wrote, but his entire body was covered in bed bugs. The report also goes on to note a severe bed bug infestation in the inmate cell in the psychiatric ward. Thompson's cause of death, the report shows, was listed as undetermined. Probably eaten by the bed bugs, right? You got all these bed bugs slowly eating at you, slowly eating at you. Mr. Thompson was found dead in a filthy jail cell after being eaten alive by insects and bed bugs. The Atlanta-based lawyer Michael D. Harper said Thursday, "We're asking for a criminal investigation into the matter and major changes at the jail." Yeah, you think? A lawsuit in the case is pending, Harper said. Bugs, lice, and other vermin. The Fulton County Sheriff's Office released a statement to USA Today on Thursday extending its condolences to Thompson's family. According to the statement, a full investigation was launched into the circumstances surrounding his death. As a part of the ongoing investigation, action taken included approving additional expenditure of $500,000 to address the infestation of bed bugs, lice, and other vermin within the jail, which was done in addition to prior cleaning operations targeting communicable diseases. Not fit for diseased animals. So there's a report where a man just gets eaten by bed bugs. So is that a case that Amy Coney Barrett thinks would be important enough? Because this happened in 2013. This Taylor v. Riojas. Taylor v. Riojas 2020 eventually gets to the Supreme Court. 7 years after this shit happened. I mean, it would have been smarter for the private prison officials to just let him die in that waste and piss and shit jail cell. They would have been smarter tactically. Maybe their conscience would have allowed them to be able to do it. They allowed them to throw him in jail for, 6 days. So, and then the district court and the Sixth Circuit Court both are going to say that qualified immunity. You didn't do your paperwork right. Hey, you're not supposed to. Summary judgment isn't supposed to go to the Supreme Court. All this legalese, which just kind of says, we don't need to hear about this shit. It was the first case in which the Supreme Court established injustice as one of the reasons for the U.S. government. It's in the preamble. It's the sentence, the first sentence. It's sentence number 1. It was the first case in which the Supreme Court relied on the obviousness of a constitutional violation to overturn a lower court's decision to grant qualified immunity. Trent Taylor was an inmate in a Texas prison. He filed a pro se lawsuit alleging that he was confined for 6 days in a pair of shockingly unsanitary cells. District Court found no constitutional violation, granted summary judgment. The Fifth Circuit found that Taylor's rights were violated, but concluded that summary judgment was appropriate because the defendants weren't on fair warning that their specific acts were constitutional. What, Your Honor? We had no idea. Then the Supreme Court summarily reversed in a per curiam decision. Justice Alito concurred in the judgment because he agreed with the court's decision on the merits, but disagreed with the court's decision to review the case in the first place. Justice Thomas dissented without providing a written opinion, and Alito's holdup seems to me to be very similar to what Roger Taney was saying when it came to the Dred Scott case. Here's some of the legalese that you had Taney talking about when it come to Dred Scott. I think it was Taney. Yeah, Roger Taney. When a plea to the jurisdiction and abatement is overruled by the court upon demurrer, and the defendant pleads in bar, and upon these pleas, the final judgment of the court is in his favor. If the plaintiff brings a writ of error, the judgment of the court upon the plea and abatement is before the court, although it was in favor of the plaintiff, and if the court erred in overruling it, the judgment must be reversed. And a mandate issued to the circuit court to dismiss the case for want of jurisdiction. To this plea, the plaintiff demurred and the defendant joined in the demurrer. The court overruled the plea and gave judgment that the defendant should answer over, and he therefore put in sundry pleas in bar. Sundry pleas in bar. Sundry is just a smart word. It has nothing to do with, it's not even legalese. Upon which issues were joined, and at the trial, the verdict and judgment were in his favor, whereupon the plaintiff brought this writ of error. So you're supposed to read the rules of evidence, read the rules of procedure, read the Constitution, read the statutes, read all the case law, and then file the thing timely in the right way to do it this way, that way. And if you don't do everything fucking perfect, well, Amy Coney Barrett isn't going to hear it. And then Justice Thomas is going to be against it. No, I don't need to hear this. No, I dissent. I don't want to hear about this shit. He don't want to live in this shit. You don't want to hear about the shit? He don't want to live in shit for 6 fucking days. And nobody wants to get eaten by bed bugs. So it's incredible to me that, we want to establish justice. Some of these Supreme Court cases, you'll have like a guilty man is going to be set free because of some procedural mistake, and then you have an innocent man who gets fucked over because of some procedural mistake. Nobody is going to be pissed off at the Supreme Court for instituting justice. Miranda, I like the Miranda warning, but if they would have said that Ernesto Miranda should have been convicted, I would have been okay with that too. They could have just put it in a dissent. They could have waited for another case to do the Miranda warning. Ernesto Miranda, he was convicted of raping a woman, and then they released him, and then he committed more crimes, and then he's going to get gunned down, and he had the Miranda card in his back pocket. So when it comes to a toxic case, you don't need to make your fucking points on a toxic case. You had Rahimi. The Rahimi decision is Clarence Thomas sitting there saying that a domestic violence abuser should be allowed to keep his guns. Well, Rahimi wasn't just shitty to, the girlfriend or the wife or whatever. He was also shooting guns all over the fucking place. He got in a road rage with somebody, and there was a person that was pushing the car, and he fired the gun at him. And then there was another, when he got in the argument with his girlfriend, somebody was watching, he fired the gun at them. And then he was selling drugs to somebody, and then they disrespected him, so he took an AK-47 and shot into their house. He just kept using the gun over and over again. There's like 5 instances of Rahimi being a piece of shit. So Justice Clarence Thomas, he makes, some interesting points about with the restraining order. His point is very simple, actually. He's saying with the restraining order, you can put the restraining order as an emergency temporary measure, but without a hearing, without notice, without due process, you can't keep it on him, and you can't keep it on him for life. It's almost a conviction before the conviction even happens. You're giving them a punishment before there is even a trial or a conviction. And so that's his point. That's his only point. Is that, once you throw this emergency protective order on him, if he breaks it, because it's not just can't have a gun around that person, but you can't have a gun at all, you break it, then you get thrown in jail for 15 fucking years. But what a stupid point for Clarence Thomas to make on top of Rahimi. Rahimi is a dangerous person, a fucking psychopath who doesn't deserve to have any damn guns. Not only should he not have guns for the safety of his wife and kids, for the safety of everybody, for the safety of the entire community. So interesting that Clarence Thomas could see, a domestic violence situation and say, hey, give that guy, that Rahimi, a pass. But with Taylor v. Riojas, Trent Taylor, he can't see that Trent Taylor should be given a pass or should be protected. Give the fucking cops a pass. And then not the cops, the prison guards. And a lot of prisons are private prisons. So these are private prison guards. This is just a private business. It's not cops with state authority. It's a private company that has their employees dressed up in uniforms. And their employees dressed up as uniforms that look like cops under the color of law as cops, but not really cops. And then Amy Coney Barrett, she can't be bothered to weigh in on this. So per curiam, that would be 7 out of 9. And then Alito says, okay, I'll take this case. But here's the problem. Here's the problem that I have with this case, which I guess is interesting. It's a procedural matter, and we need to make the procedure as efficient as possible. So I kind of appreciate Alito's, explanation. Well, how come Amy Coney Barrett doesn't explain why she didn't fucking vote on this shit? It's alright for men to live in a bunch of fucking shit for 6 days. Why don't Amy Coney Barrett, why don't she live in shit for 6 days? And then get back to me. Clarence Thomas should live in shit for 6 days. And then see if he dissents with the idea of him being thrown into a pile of shit for 6 fucking days. Hey, Clarence Thomas, do you dissent to this behavior? You're okay with this behavior? You can endure this. You can tolerate this. This is A-okay. So it would have been okay. Rahimi, I don't know really what the court thinks about restraining orders. If you have a restraining order and the guy just sues based upon the restraining order, and it's just, one little thing, and you don't have this rap sheet, so he messes up once, and then now for the rest of his life he's going to be deprived of his civil liberties with the Supreme Court. And what if there's no conviction? What if there's some kind of plea or dismissal? Let's give him the benefit of the doubt. He was accused of something, got a restraining order, and then the case is dismissed. So do we keep the restraining order on him? Is he forever barred from ever having any of his civil liberties ever? If you get a case like that, Clarence Thomas, jump on that case. And I don't even understand the Taylor v. Riojas. Well, he didn't do the procedure thing right. Motherfuckers, if you can establish justice, establish justice. You can make your little fucking points later on, your little Supreme Court little fucking ideology points with some other case. I would rather you institute justice. I like the Miranda decision because cops had to do a professional development all across America. Cops had to learn those few words, and actually if you watch cop shows, they look badass as fuck. You got a right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney, and if you can't afford one, then one will be given to you. Well then shit. That's awesome. That makes the cop look professional, makes him look like he's all about business, and then once he told you his rights, now where the hell were you on the night of October 2nd, da-da-da-da-da. That looks fucking good as shit. So after the Miranda decision, cops all across America had to do a professional development. They had to study professional development. They had to get better up on their game. This is good for everybody. This is good for everybody.